So no matter where you go, no matter on the internet, in all sorts of societies, they don't. If you go to Germany, they don't learn how to speak Portuguese there. What do they learn how to speak? German. And German, yes, of course, German. And what else, right? And English, right? And in China, you've got classes in English. I bet you there's not a lot of people taking Portuguese in China, right? But there's lots of people who will take English, right? And English is everywhere. And in Quebec, they're surrounded by English, right? Like literally on both sides, right? They're going, well, we got to stop this infusion of English into our society. So they decided to pass a law. And the law was, in any public place, anywhere in Quebec, that's the province of Quebec, anything that is displayed in a language other than French must have the French equivalent placed with it. And the French must be more prominent. So if you had an English area where there was a stop sign, it has to say stop on it. And what else does it have to say? Arrête, right? And the arrête has to be more prominent, which generally meant bigger. Yeah. Right? So if you had a sign that said, Murray and Friends good shoes, and I have to have that in French. Murray et ami. I don't know what shoes are, right? And the French has to be bigger. And if you go to an Irish bar in Quebec, and on the wall there's a mural that says, "May the leprechauns of Ireland blow sunshine up your arse." Right? Because that's the way we people of Irish talk. We talk about leprechauns and arses. Okay? So, and sunshine. We're big on sunshine, leprechauns, and arses. So, may the leprechauns of Ireland blow sunshine up your arse. Then, right next to it, in more prominent, who can speak French? Okay, can you do the translation for me? Because that's what's got to be there. Right? And it has to be more prominent. And this was a pain. It was expensive. People had to change all their signs, everything else. And a number of people challenged the law. Remember, the only way around a statute is it has to be declared unconstitutional. So it was a law about language in French in Quebec. It only applied in Quebec. And I'm going to tell you, it's not a Section 9192. Quebec has the right to make laws about what happens within their borders. Okay? So that wouldn't work. So what argument did they make? What argument?
Equality.
Why is there an equality argument there?
Because people who may not know French, or the equality of the businesses that have work under another language having to spend more money than their counterparts.
Those are good arguments. One of the most important factors in this case was the fact that the French had to be more prominent. That is not equality. Who's that favoring, folks? The French, right? And people who are English, they don't have that. They made an equality argument. Is that a good argument, folks? If you were a judge and they said, this is taking away equality, would you say yes or no? Is it taking away equality?
Yes.
Good argument, right? So then what happens? That's not the end of the story with charter rights. It's an important first step, but it's not the end of the story. Now what do? Where do we go next?
Argue it.
No, but there's a sequence of arguments that will be made. The first argument is there a right violated? And what's the answer?
Yes.
You say yes. Where do we go next? Is that the end of the story, folks? If they take away a right, is the law invalid?
Yes.
Not yet. Okay, remember the Incas, right? Remember I talked to you about Incas? And I was saying, okay, we're going to march the Virgin up the mountain. Remember that? Yeah, that was funny. All right, so we're marching the Virgin up there, and I'm going to go, that's my religion. And they're going to go up against the car loan here. And can they take away my right to religion? Yes, they can. When what? What? I heard it. Society accepts that that right should be removed. You don't get your right of religion if that's what you're going to do with it. Right? So, the first question is always, is there a right violated? And the second one, though, is, well, the society accept removing that right. So which right was being removed again? It's important to know which right. Equality. Is that one that society says, take away our equality rights? No way. Right? This is one of the biggies, right? So, the argument was, look, it was really important. We're protecting culture. And the court case said, culture is important, equality is important, culture is important. We accept that. But how many different ways can you protect your culture? What could you do? Quebec? What could they do? They could have festivals. They could hand out French-English dictionaries at the border, right? They could have free lessons for French. They could invest in television shows that are only in French, that are actually good, right? They could do all sorts of things. They can protect culture without removing equality rights. Because of that, the court struck it down. So what did Quebec do? There only is one. What does Section 33 say?
They can take the rights and take away any right at any time.
As long as they
Say the way.
Say they're going to do it.
and
Do it for 5 years.
they have to put a time limit on that removal of that right. So they have, and they've done it every 5 years since 1980. That law is still in place, and it cannot be struck down because of Section 33. Can't be struck down. Because according to the whole of the Constitution, it is valid. Because this upholds it, even though, and that's part of the rules. Did I talk to you about Doug Ford?
Yes.
Did I? So what happens if we just say, okay, screw all these laws. I'm just going to take away all these rights, and I'm going to use Section 33. Section 33 has been used twice. Did I tell you that? Once for this. That was the one time. It's been used year after year after year. Because although there's a 5-year limit, it can be renewed. And they have. And that's the law. Until someone decides that they're going to vote in someone who isn't going to pass that. Okay, we're going to finish this with what I think is one of the most fascinating questions, or fascinating cases. And then I'm going to give you homework on this. So, Manitoba. Are you guys familiar with the smoking rules now? All right, does anybody know what they are? Anybody smoke? Who's a smoker? What aren't you allowed to do? You're not allowed to smoke where?
Yours.
Yeah. Basically in any public place, right? You can smoke in your house, right? Can you?
Yes.
As long as you don't have kids there, right? Or even if you have kids? But you can't smoke in your car with kids in, right? No. Right? So, you can't smoke in any public place, right? And there's some other rules about kids and cars and stuff like that. I don't know all that stuff because I didn't have to worry about that too much. So, there was an interesting case. Now, I'm going to ask again. Are there any people there, is there anyone out here that smokes more than, let's say, 8 cigarettes a day on a regular basis? Anybody? No smokers. That's pretty good. So, okay, so I've got no people that you would call yourself smokers, apparently. But here's my more important question. How many of you smoke sometimes? On occasion, you will smoke. Put up your hands if you smoke sometimes. And when do you smoke? Tell the truth.
Well, like sitting at home.
Really?
Doing laundry or something.
Really? Well, that wasn't the answer I expected at all. Okay? Quit that. Bad for you.
The I smoke when I drink. Is usually the excuse people have.
Yeah. A lot of people who don't smoke at all will smoke when they drink. And when the smoke, how many do that? How many of you tend to smoke sometimes when you're having a few drinks, okay? So I don't know what that is about that, okay, but apparently it's a thing, right? And it's such a thing that when the non-smoking law came into place, the people who had bars had about a 30% drop in revenue. 30%. Because people didn't want to go to bars where they couldn't smoke. They would sit at home and drink and have some cigarettes there. It really had an economic impact. So, the way that the law was worded was basically says you can't smoke in any public place, blah, 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 blah. But this law will not apply on Indian reserves. Why did the government exclude First Nation reserves from that law?
Smoking a certain tobacco is part of their spirituality or religion.
So there could be a cultural thing, and there's another issue, which is that, what is it?
We don't have right to govern laws.
Because
Write
first,
laws that govern native land.
yeah, so anything having to do with what are referred to as Indian affairs is under the federal government. If you pass a law about what people on reserves can do, you're making a law about Indian affairs. So they basically said, we're not going to make this law apply on Indian reserves. Why not? Because they didn't want this law struck down as being contrary to as impeding in an area that was given to the federal government. Do you understand that? So, there was this guy that had a bar. Now, one thing that you do not see amongst those rights is economic rights. There is no charter right to make money, right? There's nothing in there about it. It's clear. And there's been cases on it. You don't have the right to make money. It's not a charter right, okay? So, he had a bar and his revenues went way down. So he decided to fight that law. Does anybody have any idea what argument he would make? So, what's the law about, folks? Let's start with that. What's it about? Why do we say you can't smoke in public places? What's the law about?
Health.
It's about health, right? It's about health. Who has the right to make laws respecting health? And did the province make the law? Yeah. So did the right government make the law? Had they specifically excluded First Nations so they would not be accused of stepping into an area that they're not allowed to make laws on and therefore have the law struck down, right? So now what? So what argument did he make?
Does it have to do with the freedom of association?
No. They may have made that argument. It's a small argument, okay? It wasn't the big one that they made. It's not, I can understand why that, and it may have been argued in the case as a, let's throw this out and see what happens. Equal, right? They made an equality argument. The guy said, this isn't fair, right? Because Swan Lake First Nation is near Treeherne. And he says, okay, imagine these two situations, right? Me over here, I have a bar, and no one can smoke. If there's a bar on the Swan Lake First Nations, can they smoke? Yeah? And he says that is not equal. He went to court. The guy in Treeherne went to Queen's Bench Court, won. Struck down. He went to the Court of Appeal. It got appealed to the Court of Appeal. Court of Appeal struck down the law, unequal. But you know that the law is still there, right? Why? Because it went to the Supreme Court of Canada, who, and I've read this case, folks, and it's very clever. They said there's no breach of any right here. We don't even get past first base. But it was a thing because if they fixed the equality argument, it could be struck down because of this. If they said, okay, it applies everywhere, then 91 and 92 could cause it to be struck down. If they don't fix it, this part of the Constitution can cause it to be struck down. So if they fix it, it gets challenged for that. If they don't fix it, it gets challenged for this. And this is the only case that I'm aware of where the two sections of the Constitution were creating a situation where it would be impossible to make this law. Right? Where if you fix this, they lose that. If they fix that, or if they leave it the way it is, so this would be cause it to be struck down if they removed, if they made it for everybody, right? Because they're infringing on First Nations culture and First Nations, the area given to the federal government. But if they make it everywhere, this would be used to strike it down. But the Supreme Court of Canada said, there's no issue. There's no equality argument here at all. And you went, well, wait a minute, sure there is, right? This is pretty unequal. And what they said was, no. They said, okay, what happens if someone from Swan Lake opens a bar in Treeherne? Can they smoke there? And what happens if a guy from Treeherne opens a bar on Swan Lake? Can they smoke there? And they specifically, I remember reading about this, it says, and nothing in the Indian Act would prevent that. In other words, there was no laws that prevented a guy from Swan Lake or from Treeherne opening a bar on the reserve. There were no laws that prevented that from happening. They said that there could be all sorts of, self-government and the community itself preventing it, but there was no law in the Indian Act that prevented it. So that could happen. And would the law be the same for the guy from Treeherne if he has a bar here? So this is saying the law is the same for everybody. This isn't about who, it's about where. And therefore, the where is the same for everyone, and it's equal. And they kicked the case out. And that's why we can't smoke in our cars. Or in bars. At this point in time, I'm going to give you a hard bit of homework. This is not for marks because you're not going to be able to do it particularly well, probably. Most of you are going to struggle with this. That's not the point. The point isn't to get it right and hand it in. The point of this exercise is for you to try and figure out what you don't know. The way that I teach sometimes, folks, people can follow along the bouncing ball. They think they understand it. But if you can't use it, you don't get it. You might know it. You might be able to write it all down, but you can't get it. So what I'm trying to get you to do is to try something to see what you can do and what you can't do. And then we're going to come back next week, and we're going to fill it all in for you so that you can start with saying, okay, I don't understand this. And I know I don't because I can't do this. Okay? There might be a couple of you in the room. There might be a few of you, I don't have any idea, that can whiz through this. You got it all. It's not very common that happens. But my point is this. Don't worry if you can't do it. What you're trying to actually find out is, what are you actually able to do? And this is what I want you to do. I want you to create a flow chart that takes into consideration all of the parts of the Constitution that we've used. And this is how I want you to envision it. I'm going to start you on the process, okay? I'm going to show you what I'm trying to get you to do. And what your job is to try and finish it. Okay? See if you can put the pieces where they belong. So, on a test, I may give you facts. Remember, the test is open book. But if you don't know what you're doing, it doesn't matter. Okay? It's an open book exam, right? You can bring any written materials, not electronic. Do not bring your computer. It's got to be in paper form. You can print off all the pages on your computer, but you can't bring the computer, okay? Or have any other electronic devices on. Okay, so you with me on that so far? All right. So I will put something on the test. The first thing you've got to be able to do is identify that we are dealing with this area of the course. It's about the Constitution. There's many ways that we can deal with the Constitution, but you have to be able to identify this question isn't about statute law, it's not about torts, it's about Constitution. So I'll give you a fact situation, and I want you to presume that you identified this as a constitutional issue. Okay? The facts are things. You've got to need the Constitution to come to the correct answer. Now what I want you to do is create a flow chart that no matter what this is, you can walk it through the flow chart and come to a conclusion, no matter what it is. Okay? Because every part of everything you've learned is going to be in the flow chart. So, in my view, the proper way to start this is, when you look into these fact situations, you've got to determine, is this a fact situation about a statute? Or a behavior that doesn't have a statute yet? You'll be able to tell that by looking at the facts, right? So the fact situation is, Murray is shown to mark people of a certain ethnicity 20% lower than any other person. Okay? Would that be a statute or a behavior? Is there a law that says Murray has to do that? No. Which makes it a behavior. By the way, I don't do that. Okay, just point that out. Do you guys know a couple things you should be aware of? You guys are aware of what an open book exam is? If you have any questions about what you are or not allowed to do, you can address them. But basically, you can bring any written material you want to the test. But it has to be in a written form. Got that? The second thing you should be aware of is that the only thing I want you to put on your test is your student number. Although I don't know very many of your names, right? It shouldn't matter, right? It shouldn't matter if it's somebody I know or someone I don't know. And that allows me to mark with an open mind and mark you fairly. Okay? I don't want you to put your name on. I want you to put your student number on. And if you can't put your student number on, like let's say you forget it, or you forgot your card, I'm then going to get you to put something that you can relate to, like your address or something. I actually don't want your name on there. Okay? Just the way I mark. Okay? I like the idea of you never have to worry about bias. Okay? Because it does happen. Okay? It's hard sometimes to, the person that was doing so well in class, and then they bomb the exam, and you can't believe that they bombed the exam. So you figure that maybe you must have done something wrong in the marking. That type of bias, I don't want. Right? I want the person to bomb the exam if they bomb the exam, right? So that's why you mark it blind. So there's a question on the test. This is a constitutional question, and you've identified it as being a behavior which you want to identify is what's the next question that you need to ask then? Walking your way through something that can be divided up into steps until you get to endpoints. And when you finish, if you've done it right, everything you learned about the Constitution should be in the flowchart. This is a hard assignment. It's not for any marks. It's to teach you something. But you got to do it at home. Questions? Question?
I don't know how to formulate my question. I'll think about it until I get to 5.
Okay, let me just make sure I'm trying to be clear, okay? The Constitution is composed of pieces, but you have to understand what those pieces are. And what I'm asking you to do is to put those pieces into a flow chart that you can take a question on the exam and walk through it and get to the answer or the end point. The only way that that's going to work is if all the pieces are up here somewhere. I'm asking you to try and organize a process for putting the pieces together. I've actually showed you how to do this several times in the examples I've given you, but I just haven't identified what I was doing. What I want you to do is say, okay, put this together. If you can't, that's okay. I will show you how to do this next week. But what I want you to do is try to put it together. There could be more than one way. Okay? Come up with something and don't worry about it too much. You won't be handing it in. I won't be seeing it. It's just an exercise to help you understand something. And most importantly, it's an exercise in helping you understand what you get and what you can't put, you don't know where to put it or how it fits. So just try, okay? And don't worry too much about the problem. But what I would like you to do is, if you have a problem with doing this, try and think about why you're having a problem. What is it that you don't understand yet? What would you need to know in order to fix it and get your knowledge to the level it should be? Okay? That's the most important thing, is to reflect on what you understand and what you don't. I sometimes have students who will, maybe contact a former student to try and get the answer. That's so stupid. Because what the hell are you doing that for? So you come here and feel really good about the fact that you copied the right answer from someone else? Okay? That's not the point. Okay? And that actually would be the worst thing to do, because then you wouldn't know what you don't know. You would actually think you got it, and that's really bad. Okay. Oh, shit. Forgot something. Something I need to do. Okay, not much I can do about it now. All right. How many classes do we have before the midterm? You guys got course outlines, don't you? How many?
3.
3 more after tonight, and then the midterm on the 4th? Okay. Good.
On the 27th?
I don't know.
4 classes.
Yeah, but actually there's a...
Oh, but we don't have a class on the 20th.
Yeah.
So what's the date today?
28.
So we have the 30th, the 6th, and the 13th. 3 more classes, then the midterm, right? Okay. Something I was going to bring tonight, and I forgot, and I'm going to have to bring it next week. It's not going to be a big deal, but it's going to relate to what we're going to talk about. There's a little exercise. There's another exercise I need you to do as a practice exercise. So I'm going to have to make sure I bring that for next week. So at some point you need it. Okay. But what?
Nothing.
That was a big sigh. All right.
Murray,
Yeah.
where are you going? Just back to Quebec taking away the right to equality.
Yeah.
With that, are they taking away that whole section, or just based on that law?
Just based on that law. That's an important question. Sometimes misunderstanding. You took management from me?
Yeah.
Remember I told you about people who know what they're doing? Shitty teachers? Right? Remember that?
Yeah.
Okay, well, this is an example of that. That's so clear to me that sometimes I gloss over it, but I can understand why I won't. No. What they say is that the right is removed for this law. They did not remove equality for everything when they took it away for that law. They only take it away for that law.
I figured that, because then I would open up a whole...
Yeah. But it's still a good question, and I've actually thought of that or been asked that before, because to me it's clear, but if you're not familiar with that, it could be vague. Always ask about anything that is not rock solid in your head. Okay? I really want you to do that. It's important to me that you ask, because I can't see the way you've understood what I've said if you don't talk to me about it. And it's so clear to me. Go ahead.
Or going back to things in your example, with the Vancouver Sergeant, you said, that behavior suppressed people's right to assemble.
Right.
And that gave people the right to
A remedy.
a remedy. Okay.
A remedy could be anything. It is almost always an order that the person not do it, especially if it's an ongoing thing, right? So if I was to push men at the back and put women at the front, the court would say, you stop that. And failing to do what a court says is contempt of court, you could get thrown in jail for it, but the court will say, stop that. And the people that were oppressed by what I've done, the right was removed, they may have a possibility of getting compensation. The people that were pepper sprayed, it's not going to be enough to say to that sergeant, you're not allowed to do that again. He seriously took away a right of assembly, the things, he physically attacked them, basically, when he had no right to do it. They got money. I don't know how much. I think it was settled out of court, so we don't know how much. So it will almost always be an order that action stop. It will sometimes be an order of money. It could be anything. It could be that I'm ordered to apologize. It could be I have to take classes. The judge, a remedy is a broad option when it comes to the Constitution. It could be anything that the judge thinks should be done. Okay. So we started this course, and I talked to you primarily. I mentioned statute law because I said you knew about it. Remember that? And then I went in and spent quite a bit of time having you understand what common law was. Remember that? Yes. And then I showed you what statute law, how it worked. Right? Do you remember that? So, no person shall operate a motor. Remember all that? So, there's a laddering that's occurring here, and I just don't want you to lose sight of it because it's going to help you understand how we're going through. And what I'm doing is I'm taking a piece and getting this sort of massaged and polished, and then we're going to go over here and get this. So we started off, I just mentioned statute. I said, what law do you know about in Yohan? Government-made law. I said, okay, good, that's statute. Let's go on and talk about common law, right? So we touched on statute for just a second, and then we dealt in much more detail in common law. Remember that? You know, about how it worked in 1066 and all that stuff. And then we came back and we said, okay, but how statute law worked? And we went through all of that, right? And then we went over and we said, okay, then we've got this thing called the Constitution that basically impacts on statute law. Because it's about where the governments get the right to make laws. It says it's government-made law, it's statute law, right? So this is about the things that are above the statute that restrict a government's ability to make statutes. It's still statute law. Although the courts will interpret when a constitution is breached, and that is common law. But the Constitution is really about statute law. It's really what it's about. It touches into common law, but it's really about statute law. Okay? So now what I want to do is I want to go back to common law. And I'm going to kind of finish off an area that you need to have the pieces sort of fit. And what I want to talk to you about tonight is the court system and how it works. So there are levels of courts in Manitoba. There isn't one court that all the judges are the same. There's actually levels of court. And because I'm going to draw this up here, so wait a second, let me see. So I got to start at the bottom. So the smallest, least important judges in Manitoba are people that are known as magistrates. Magistrates are at the bottom. These are people that if any of you have ever had a ticket for anything, including a parking ticket, you're being charged with an offense, not necessarily a crime, but an offense, and you've got to go and pay that ticket. You are pleading guilty in front of a magistrate. Anytime you've had to pay a ticket, you've been in front of a magistrate. Okay? Because that's what they do. They take guilty pleas and give you usually a set punishment for very, very minor offenses. The only really interesting power that they have is they can also issue search warrants. So they can issue search warrants. So a police officer who wants to go search a place and needs a warrant can get it from a magistrate. These people are generally not fully legally trained. They have a bit of training, but they're basically government workers who got that job. Okay? They're very low down on the qualification level. Moving up in Manitoba, the next highest court is what's called the Provincial Judges Court. The Provincial Judges Court, these are lawyers who have been appointed to be judges. They have a good background and understanding of what the law is. They only deal with criminal cases. And generally, they don't deal with particularly serious criminal cases. They can, but they deal with less serious to moderate to fairly serious, but the high cases generally don't go here for reasons that I'll explain. Well, I'm not actually going to explain. I'm just going to tell you. They don't go there. Okay. So, but the point that I need you to understand is this is for criminal law. It has nothing to do with business. Unless you're thinking of going into illegal business, you don't really need to know about these people. Okay? But I do want you to understand that they're a level higher. Okay? Moving up in Manitoba, we have the Manitoba Queen's Bench. And when we get a king, that will change to the Manitoba King's Bench. Because it's only called Queen's Bench because England has a queen. And it goes back to the King's Court in 1066. This court can hear any type of case. Any type of case. They can hear family cases. They can hear wills. They can hear criminal cases. And for our purposes, they can hear lawsuits where you sue. There is a division of the Queen's Bench that sits about here. They're above magistrates, but maybe lower than provincial judges. And this is the Small Claims Court. We're going to talk about that tonight. These two courts are the only courts in Manitoba that you can sue in. You can't sue anywhere else. There is no other court. Magistrates, Provincial Judges Court, Manitoba Queen's Bench, and then the division of them, which is a lower down court called Small Claims Court. It's for suing in small claims. We're going to talk about that today. And these are the only courts that actually hear witnesses. Because as we go from here, we go up to the Manitoba Court of Appeal. This is an appeal court. It's in a court for hearing appeals, almost always from Queen's Bench. So if someone doesn't like a decision of a Queen's Bench judge, sometimes they can go and have it reheard, sometimes, by the Manitoba Court of Appeal. But they don't deal with witnesses. They deal with paper. Everything gets given to them in the form of transcripts of what was said. And this is actually pretty important for a reason I'm going to explain in a minute. So they don't hear witnesses. They read what was stated. Okay? And this is the highest court that is in Manitoba, the Manitoba Court of Appeal. Moving up to the very top is the highest court in Canada, and it is the Supreme Court of Canada. Supreme Court of Canada. I'm going to guess at a few of these numbers because I don't go out and count or go check, but my guess is in Manitoba there might be 700, maybe 1,000 people that are magistrates. I might be low on that. Because you're going to have 3 of them at City Hall for parking tickets, and a couple of them, at the courthouse for speeding tickets, and then there's a bunch in Winnipeg and everything. And, you got to have somebody on there in case someone wants to do it, and they're cheap, so we got a bunch of people that would be considered to be a magistrate. That might not be their only job. There might be an accounting clerk that's also a magistrate for when they need somebody. I don't know, okay? So the way that precedent works, the way that common law works, it isn't quite what I told you before. The way it works is precedent only actually works down. So what that means is magistrates have to follow provincial judges' rulings. They have to do same facts, same outcome. But they don't have to go sideways. They normally do, but they don't actually have to. So they can all do whatever they want until a provincial judge says this is the rule. And then they all have to follow it. And the provincial judges often obey or go with what each other did, but they must do what the Queen's Bench. So when this law is made, these people have to follow it, and these people have to follow it. Now when these people make a determination of what the law is, everybody, all the judges have to follow it. And when Supreme Court of Canada says this is the rule, that becomes the rule for everyone in Canada. So, precedent actually only works, is required to work down. It often works side. So if this judge makes a decision, most of the other judges will say, that's the decision. Jane made that decision, and we're all going to do the same thing. That is normal, okay? It's not a requirement of the law. It's a normal practice that they will follow whatever thing. They will almost always use the same fact, same outcome, sideways. But they have to use it down. So, there's probably, like I say, a whack and pile of these. My guess is there are probably 100 to 120 provincial judges in Manitoba. And they hear a lot of different cases. There's like 4 of them in Brandon. Right? Probably a whack and pile in Winnipeg and Thompson, everywhere else. There's a bunch. There's probably about 50 Queen's Bench judges in Manitoba. There are 5 Court of Appeal judges. That's for sure. And in any case that they hear, 3 of them will sit. So if you go to the Court of Appeal and you are doing an appeal, you will be doing an appeal in front of 3 judges. There will be 3 judges, and the majority decision becomes the law. Supreme Court of Canada has 9 judges, and all 9 always hear the cases. Always. It's always all 9. there's a couple things you have to know, which is there's only one of these courts, and they don't